The MAGA-leaning Supreme Court is eroding justice and jeopardizing democracy. When you typically think of the Supreme Court and the process, we think of months of briefing, oral argument, deep, detailed analysis, and a written opinion signed by the judges where they really contribute to the thought process and outline the thinking behind a decision, because these decisions shape the rest of the law and throughout this country. Today, we're talking about how the shadow docket does the exact opposite of all of that, where just after a couple of weeks or sometimes a couple of days, the Supreme Court issues an unsigned opinion with no analysis, totally undermining lower courts, totally undermining the purpose of having a Supreme Court that's supposed to provide detailed analysis. I'm Shant Karnikian. That's Brian Kabateck. This is Civil Action on the Legal AF Network. Just a reminder before we go on, if you like this content, hit that subscribe button, hit that like button. We appreciate you tuning in. We appreciate your support. Brian, today I want to start out by I'll talk a little bit about what the docket is, what the shadow docket is, and you can talk about the issues with it and what some have to say about this. Big prominent.
And before you do that, Sean, I just want to say that I think what we're doing today, for those of you watching this is basically a preview. Stay tuned. We're giving a little bit of primer on the shadow docket, because in coming episodes we're going to talk extensively about what the decisions are that the court has made since Trump became president as part of the shadow docket. So go ahead, Sean.
Yeah. So what is the shadow docket? This is a term that's been used. It's becoming a buzzword now, but I kind of want to explain what it is. Usually, the Supreme Court grants what's called certiorari. They agree to review a case, and then they do a deep analysis of it. They hear oral argument on it, and often many weeks or months later, they issue a long written opinion, and there's concurrences, people that agree. There's dissents, people that disagree, justices that agree and disagree, and it's signed, and there's a deep explanation, and some people, others disagree with it, but it becomes the law of the land. Well, what the shadow docket is, that's when an order or a summary decision is issued by the Supreme Court outside of its normal merits-based process that I just described. Those involve full briefing. This is oftentimes without briefing. This is oftentimes they look at an order from a lower court and they issue something within a few weeks, and sometimes even days is what we've seen. And the orders are very brief, sometimes just a couple of sentences, maybe even one sentence, and they're often unsigned. So the problem there is there's no explanation of who went in which direction, who voted for a yes or a no, or who voted to issue the injunction. It's primarily, historically, it's not a bad thing. It's not a forbidden thing. It's historically used for non-controversial procedural sort of matters, not for high-stakes substantive decisions, substantive rulings. It's for, whether this process should be followed or not before the court can actually decide something. And that's how it's historically been used. But now, during the Trump administration, it's being used, or in my opinion, abused for, issuing emergency decisions, just rocket docket these things is what we're called, and just emergency decisions, but major decisions on an emergency basis. And, in my opinion, I think that's problematic. And that's not just my opinion, because I'm not some big legal scholar, but prominent legal scholars and folks that really follow the Supreme Court and understand constitutional law have major issues with this.
You're a prominent legal scholar, in your family, Sean. So I want to point out that the New York Times did a survey, and they sent a survey to a lot of federal district court judges. District court judges, remember, that's the trial level. That's the first level. That's where most of these issues start. They start in front of a district court judge. They're appointed for life. They're Article 3 judges, meaning it's a lifetime appointment under the United States Constitution. They're approved by the Senate. And these judges make these rulings. So they sent it to, several hundred district court judges. 65 responded. Although the majority of them were appointed by Democrats that responded, it was a fairly large number that, more than a third were Republicans. And the vast majority of these judges, including some Republicans, said that the shadow docket is undermining the judicial system. It's very dangerous. I will quote some of the things that some of the judges said in a moment, but I think it's important to point out one thing, is that these judges, a lot of them will work very hard. They'll have a case in front of them on an expedited matter, maybe for a restraining order, maybe for an injunction to stop something that the Trump administration is doing. They will write a 40-page opinion It will be well written. They'll probably, work 100 hours on it with their research attorneys and their law clerks. And then it ultimately climbs its way up to the Supreme Court. And one thing Shant said earlier that I want to correct, the Supreme Court isn't issuing opinions on this. Oftentimes it's a one line. The order of the district court is hereby stayed. The order of the district court is overturned. Sometimes it's 2 or 3 paragraphs. The only time when it actually gets substantive is in the dissent that the 3 progressive judges will write, and they'll write a dissent. But I promise some of the things they said, some of the federal judges candidly and confidentially have said, they've called the orders mystical, overly blunt, and a slap in the face to the district court. One judge compared the district court's current relationship with the Supreme Court to a, quote, war zone, and another said they were in the midst of a judicial crisis. And I agree with that. I think this is a judicial crisis. And this is one reason why we're trying to at least demystify what we mean initially by the shadow docket.
Yeah, I think it does 2 things, if I may. One of them is that it undermines, like you said, it undermines the process and transparency and accountability because it doesn't let us see what the reasoning is. So that's one issue. But then I think the other category of issues is it takes away from the ability to look at that precedent, to look at the reasoning behind the court, because usually Supreme Court opinions are something that the lower courts, whether it's Court of Appeals or the district courts, rely on in making their own decisions. And they look at the reasoning and they say, well, we disagree with this party here because as the Supreme Court explained and so, here's our thinking behind why we rule this way on a contested issue. There's nothing, as you said, Brian, one-liner rulings that come out that say, the lower court's ruling is stayed. And that's it. There's no analysis. So it doesn't contribute to the robust precedent, set of laws that we have that are developed through the system of having decisions go up on appeal and having it be decided and analyzed by the higher courts. There's no contribution to the precedent and to the body of law. And there's this, mystical, as you said, that phrase that some of these judges use, mystical system by which they're making decisions. So it undermines trust and it doesn't contribute to the body of law and the analysis and the deep, history that we have of legal analysis and precedent that shapes our law. Because one thing to keep in mind, I think, for the non-lawyers that listen to this is that our system isn't just based on the written laws. The decisions made by courts also are the law. That's what we call a common law system, where you have courts that interpret the written statutes that are passed by the legislature. And those hand in hand are what comprise the law. So this totally undermines the purpose of the Supreme Court to continue developing that and helping interpret those statutes. So that's a major problem.
I think, Shant, that what we let me just explain how this works in a very basic format, which I think most of the people watching this are super smart and they get this, but an issue comes up. So Trump decides he's going to fire Lisa Cook, for example, and he tries to fire her. The district court. So what happens ultimately is there's an action filed in federal court. It could be filed by the Trump administration. It could be filed by Lisa Cook, and it's to stay the action. The action then goes in front of a district court judge, trial court judge. He or she listens to the arguments, makes rulings, says, no, you can't fire. Then it goes to a court of appeal. Now, the court of appeal can overturn the lower judge or can uphold it and write their own opinion. And more often than not, they write, lengthy opinions and they explain what their rationale and reasoning is. Okay. And so in the Lisa Cook case, that's the Federal Reserve officer who we tried to fire on these super flimsy grounds. It then ends up going to the Supreme Court. And now it hasn't gone to the Supreme Court yet, as far as I know, at least as at the time we're recording this. But the Supreme Court gets the matter in front of them. And the Supreme Court can normally, in normal times, they would accept the case or reject the case. They would either grant the petition for review or deny the petition for review. And then it goes on their docket. And then it will be heard by the court, and they'll issue an opinion before June 30th of that, term of that year.
After full briefing, by the way, after
and
full
oral argument.
Yeah, and oral argument.
Public oral argument. Now that's very important. Full briefing, public, full oral argument, public, and then a public decision. But what the court's doing here is, now they haven't done this in Lisa Cook, but they come out and they say, the order is stayed and you can fire her. Now that didn't happen. I'm just using it as an example. And then there's no decision. And then are they even going to have oral argument? Well, so far they've only granted oral argument in about 5 cases. And as of today, I believe there's 25 shadow court decisions that have been made by the Supreme Court.
Yeah, that's a lot. That's pretty wild. And some of them have big implications. Some of them are very, powerful things that the Trump administration thinks are huge wins. And I don't want to say like it's a win for the Trump administration every time. There's some wins that the opponents have had, but I think generally the practice is not good. It undermines public trust. And that's a major problem. Look, my closing thought on this is that I would encourage folks watching this to kind of pay attention to the court and not just the ultimate, decision or the impact of the decision, but look at how the court is deciding things, why it's deciding it. It's very important. And, if folks on the other side that are saying, well, this isn't a problem, they're the Supreme Court, we should defer to them, share with them why this is a problem. Share with them the fact that these are things that are supposed to be done with full briefing, in public, with oral argument, so we can see the reasoning behind it, because that's what kind of gives trust to these institutions, these very important institutions like the Supreme Court. And for them to do it without any of that is not good. It really undermines the institution itself, and it undermines democracy, in my opinion.
So stay tuned. We're going to, in coming days and weeks, we're going to unpack some of these 25 or so decisions.
Yeah, well, thanks for tuning in. Another installment of Civil Action on the Legal AF Network. Again, a reminder, if you like this stuff, hit that subscribe button, hit that like button, share this with whoever you want. Share with us your feedback. If you have questions, we'd love to take a look at them and answer them for you. Thanks for tuning in, and we'll see you on the next one.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.